And if it's not, we'll just go on to the next case.
Yeah.
SJC-11505, David Gangi versus Joshua Wall.
May it please the court. I'm John Fennell, and I represent David Gangi. David Gangi's parole was revoked because a single urine sample tested positive for opiates. Gangi repeatedly requested discovery on the drug testing. He asked for the threshold for a positive test, the concentration of opiate alkaloids alleged to be in his urine, how the test administered discriminated opiate alkaloids from innocuous sources like poppy seeds versus opiate alkaloids from contraband, and the error rate for the testing. Gangi never received the discovery he asked for despite the repeated requests. And violating Gangi's parole on the basis of this evidence, which was just a piece of paper that said positive.
Is it true, though, that the decision, that the parole board only had that and no more? And so is your problem that you didn't get discovery, or that the parole board makes decisions on just that kind of evidence?
Both. And both those are captured under the Morrissey v. Brewer minimum requirements for due process for revocations of parole or probation. The parole board did not disclose the evidence against him. The evidence against him, while what the parole board relied on was simply a piece of paper saying positive.
Which they disclosed.
They
did disclose the evidence. You're just saying it's inadequate evidence.
That's inadequate. Well, that goes to its factor F under Maggio's articulation of the Morrissey-Brewer factors, that there wasn't evidence there for the fact finder to make an independent finding that the parole had been violated. Also, the bare fact of a positive test without any evidence about the way the test was administered, the way the test worked, that's not substantially reliable evidence, and there was no good cause found to deny Gangi's confrontation rights there.
So what do you say is the due process entitlement to discovery in a parole hearing?
I think it's something like the case of what the defendant needs to get is something like in Commonwealth versus Thistle, which was a probation violation case where the defendant's probation was violated for being outside of being in an exclusion zone on his GPS. And there were detailed records about the GPS records. And a probation officer testified about how GPS worked. Now, there are two slight problems with Thistle. One is that people are more familiar with the way GPS works and exclusion zones and what's a violation than they are with how drug testing works. And the second problem with Thistle is that the defendant there also admitted to being on the beach and going in the water, which was something that he wasn't allowed to do. Surely parolees are not entitled to full Crawford confrontation rights, but they're entitled to at least substantially reliable evidence against them. And if that can't be provided, then there needs to be some kind of...
But you're asking us to impose a due process right of discovery in a context in which many, many people are found in violation because of urine tests that failed. Is it your view that in every urine test, regardless of the nature of the case, the defendant is entitled to discover the underlying biology of that particular test?
If they're just relying on a positive urine test, and in particular here we have opiates, where it's something where innocuous sources can lead to an opiate test, then yes, they need this discovery. But there's something to add here, which is that I've represented probationers in district court, and when they get positive urine tests, there often are other things going on. So when we come in for the surrender hearing, in that context, their probation is going to be violated for other reasons. It's not the urine test. Gangi's case is unique here in that he was violated simply for the urine. He doesn't have a history of drug abuse. He's been following his parole conditions otherwise. And he asked for this, and this is something that it's well known that opiate tests can be frustrated by poppy seeds.
Okay, so are you saying the poppy seed evidence that you presented was irrelevant, that even if you had not presented that, you would have been entitled to it?
Well, the poppy seed evidence certainly helps, but where we have just a positive test with nothing else, I think that's inadequate, because we don't know what's going on. We don't know the test at all. We can't assume that Parole is using a test that is as exact as something like mass spectroscopy.
So what are you entitled to? What kind of information would you be entitled to?
The threshold for a positive test, the way the test distinguishes, in this case, opiate alkaloids from contraband versus opiate alkaloids from innocuous sources like poppy seeds, the actual concentration of the contraband, and this would apply for any kind of drug violation, the actual amount in the urine for the individual, the error rate for this testing, and something about the chain of custody. He needs to learn about the chain of custody and who was involved, and then if there was something to dispute here, then he could subpoena in the people who administered the test.
Did the defendant give an affidavit or anything to say, hey, I ate poppy seeds and therefore that may have affected the test?
The defendant, so at the preliminary revocation hearing, and we have a little bit of a record of that from what the preliminary hearing examiner put in her recommendation to the parole board. She discussed how Mr. Gangi said, something like, I thought I ate poppy seeds. There was bread with different kinds of seeds in it. Mr. Gangi is not a sophisticated man. He said there were these small black specks in his bread, and he didn't know what they were, and then he learned they were poppy seeds. This is what happened.
Well, it was Easter, I gather.
It was Easter Sunday, that's right. It was Easter
before the
Sunday.
test.
Breakfast was a little nicer than normal, and that's what happened here.
Did, at the hearing, was there or prior to the hearing, was there a request that the chemist or the analyst be present for purposes of cross-examination?
For the final, so the first request that the parole board received for any kind of discovery was at the preliminary revocation hearing on April 8th. And then on multiple times from April 8th until the final revocation hearing on April 26th, there were requests for discovery of the way the test was done, or the people who conducted the test who could talk about it. The request was in the alternative, I believe is exactly, but the motion is in the record appendix.
Okay, and that was denied?
It was denied, that's right. He was denied at every turn trying to get this discovery. And also, I mean, just speaking to the positive, the test, just the piece of paper stating positive, without knowing about the test, he can't realistically defend himself. And that's another one of the Morrissey versus Brewer rights, that if he knows how the test works, he can...
I don't mean to interrupt you. I'm sorry for interrupting you, but who was the analyst? I don't mean their name, but were they a state chemist? Was it somebody at a hospital? Do we know that? Who analyzed the urine sample?
All that's in the record and all that I know is that it was done at the Office of Community Corrections on Thorndike Street in Cambridge. So whatever is used there, assuming, but I mean, I don't know what they use, how it's changed, who they contract with. I did request from them directly and was denied. Well, actually, they just didn't get back to me.
So we don't know whether this was just a home test or...
We don't know if this was a cup, just a home test, urine in a cup, or full-fledged mass spectroscopy. Excuse me. Mass spectroscopy. I can't even say the word.
We know what you mean.
Spectroscopy.
The full-fledged test where they look at the orbitals for the different electrons for the chemical compound and see their electromagnetic signature. There's no published opinion in Massachusetts where parole has or probation has been revoked on a single positive drug test standing alone with nothing else. The appeals court here in a prior decision called Swanson. There they commended a judge for not relying on a breathalyzer to revoke the defendant's probation, where there was no evidence of how the breathalyzer worked or someone who could talk about how the breathalyzer worked.
There were several urine tests done here, right?
There were 3 tests done on the April 1st urine sample. So they
It was just the one sample.
the April 1st sample was tested 3 times. The April 2nd sample was tested at the parole office, and that was negative for opiates or any other drug.
So the April 1 sample tested positive 3 times?
It did test positive 3 times.
And the April 2 sample tested negative, but it was done at the parole board?
At the
They
parole,
have their own testing facilities?
at the parole office. I don't know what was done there, but in the sheet of sort of the running log of Gangi's interaction with parole, it discusses that he was tested when he reported to his parole office as required on April 2nd.
I can't remember this. Were you or somebody somehow representing him in any of this?
I represented Gangi at the preliminary revocation hearing. I could not attend the final revocation hearing, but another attorney went there in my
Okay.
stead.
Was there ever, because the same April 1st sample was tested 3 times, was there ever a request to test for tebuline, if I'm pronouncing that correctly, or?
Theobane, that was in...
Theobane? Thank you.
No request was made for that, but that was in the discovery request, was how does this test distinguish between this opiate alkaloid, theobane, which seems to be unique to poppy seeds versus opiate alkaloids from contraband sources.
You know, there are thousands of people that do these urine tests on a daily basis involving criminal justice issues having to do with all kinds of cases, different kinds of cases. So hypothetically, what's wrong with just saying, look, if you fail the test, you're in deep doo-doo. And it's incumbent upon you to come up with your expert to show why all these other alternative means, rather than putting the burden on the state for these programs, which presumably help a lot of people. Why couldn't you come up with your own expert to say, look, eating one piece of bread, with poppies on it, is enough to skew the result?
Okay. Now, I did show up and represent Gangi, but in general, at parole revocation hearings, there's no right to counsel. If we had the evidence of what the testing was, then we would know what kind of expert to hire, what we could say, what would be a fruitful strategy to pursue. At parole revocation hearings, documentary evidence is enough to put this issue into play, and that's what Gangi did. He filed articles from peer-reviewed journals and other sources discussing the poppy seeds and the way they can frustrate drug tests.
Was there a suggestion in these materials that eating one piece of bread with poppy seeds, or a Kaiser roll with poppy seeds all over the top, that will throw this test off? It will give a false positive?
Yes, Your Honor, and specifically in different testing bodies, they've advocated raising the threshold for opiate tests from 200, I believe it was. Well, let's just forget what the figure was, but from 200 to 2,000 or 3,000. So an increase of over a factor of 10 in the presence of contraband that needs to be there in the urine to decide that it's a positive test. And by increasing the amount that needs to be present, that reduces the number of false positives that occur in a
Okay.
opiate test.
I'm a little concerned that you got to be careful with what you ask for, because the legislature could conceivably say, okay, no more urine tests, everybody's going to go to jail for a certain period of time. Minimum, started playing with that approach. Would there be anything wrong with saying, informing everybody you can't eat Kaiser rolls with poppy seeds on it, and because it could produce a false positive, And if you get a false positive on one of these simple urine cup tests, you're done.
Well, I think the idea of giving notice about poppy seeds is certainly something that could be done to make this a better process. My understanding is that happens in a federal supervised release, and in my experience in probation, when something comes up with a positive urine test like this, the probation officer in the court will work with the probationer to get this out of the loop, if it's some kind of poppy seed or something the person's doing that's innocuous that's producing the positive test. But there could be other things that could produce a positive test, and without knowing the way the test is conducted, what the test is testing for, and what the thresholds for a positive test are, we could still have people's parole violated from innocuous sources rather than contraband.
So all parole violation hearings and conceivably probation violation hearings that involve a critical piece of evidence being a urine sample, we're going to have to get a mass spectrometer for all these different locations.
Well, I don't know if we're going to need to get a mass spectrometer for all those locations, but where the parole or probation is being revoked only for the urine test and nothing else, which is, in my experience, a rare occasion in probation, then there needs to be some evidence of the test and the way it's conducted. And there are urine screens that are done, and there's case law that those aren't enough. We don't know if this was a urine screen. I see I'm out of time. I just would like to rest on my brief and Attorney Eisenberg and the attorney for RSA's arguments.
Thank you.
Thank you.
Good morning. May it please the court. Assistant Attorney General Ryan Furch on behalf of the Parole Board. The due process requirements, as was pointed out earlier, at a parole revocation hearing are well set out, and those requirements were met here. Mr. Gangi was provided with the tests against him. That was all, and the parole board told him.
Provided with the results of the test.
The results, that's correct. The results of the test, and the parole board conceded that that was the evidence that it had in front of it and didn't have this other background testing that he sought. Furthermore, and I think it's an important point that hasn't come up yet, is that Mr. Gangi testified at the first revocation hearing, and it was within the hearing examiner's role to gauge his testimony and weigh his credibility. And in the record, it shows that he said, I may have eaten something, I don't know what was in it, it might have had these black seeds. That was up for the hearing examiner to determine how credible he was and whether or not this other, I guess, new discovery should be ordered.
Are you aware of any hearing in which a defendant advanced this kind of an argument and the hearing officer said, well, okay, that's legitimate, I'm not going to violate your parole?
In terms of a urine test, the parole board's not aware of anybody challenging the urine test specifically, but I would point out that the parole board, the purpose of the hearing test is to take a holistic approach to parolees and violations. And then there's a range of possibilities that the parole board has. There's multiple examples of the parole board finding maybe that it was a violation, but it deserved a warning as opposed to a full revocation. And furthermore, again, he had the time to develop, let me take a step back. Even though the hearing officer didn't find his testimony credible, she admitted, I don't have those results in front of me, but here's how you can get them.
It's odd that you would say that it's a holistic approach when this gentleman apparently had no history of drug abuse and has a urine screen that turns positive, which is apparently atypical for him. And in those circumstances, to do no further inquiry. It's odd because it's not really in keeping with a holistic approach.
I say it's a holistic approach because in the record here, and as part of the statement of facts, because of his lack of drug history, his testing was actually scaled back. So he had to go to fewer drug screenings. And then there was other examples where he'd received warnings for other different types of parole violations. So again, the goal, if I can step out of Mr. Gangi specifically, the goal of parole is a dual role of safety for the public and trying to integrate parolees back into society.
But he was violated because of the drug screen.
That's correct.
And only because of the drug screen.
That's correct.
Mm-hmm.
Could I just ask, is this a part of the record, I'm following up on that question, he had been, as part of his CPSL, required to go to drug treatment, but they discontinued it?
I'm not sure if that is part of the record. My understanding of the record of the stipulated facts is that his drug screening was reduced, I believe, in August. And I don't want to misstate it, but that it was...
Drug screening is required of everybody, even somebody, let's just say for the moment, who was required to go to CPSL, and as part of that goes to drug treatment, but is graduates for drug treatment because they don't have a drug abuse problem.
Right.
everybody.
Drug testing is required, yes.
Now,
Doesn't the fact that the very next day his drug screen was clean suggest that support his argument that he ate poppy seeds?
Not necessarily, because it depends on the chemical component of the drug at issue. Certain drugs metabolize and move through the body very quickly, and even the articles that he submitted suggest that whether it's a poppy seed or a true opiate, poppy seed and a true opiate are both true opiates, just different levels. Even the articles he submitted suggest that poppy seeds move through the body in a very rapid rate and are oftentimes not detected within 24 hours. And that's another point here. His testimony was that he ate whatever he ate. That's true.
Poppy seeds move. If it's a higher level, it also moves very quickly?
They move...
Just saying, if it's a poppy seed, it moves. Because this was, remember, it was Sunday, that was Easter Sunday. The next day was the urine test.
That's correct.
So it was 24 hours. So very quickly.
Yes.
And then the next day was gone. So what is it that moves through quickly, poppy seeds or a contraband?
Both, my understanding, and I apologize for not being a chemist, but both move through quickly. It just, again, it depends on the amount that you start with in the system as to how quickly it's going to move through. And it's not unheard of for either to move through within 48 hours. And I believe the record here from the testing center said, and I don't want to state, they said it was below the threshold for a positive test the April 2nd, but that could just be indicative of whatever the drug was moving through his system. So that was considered by the drug testing center and provided to the parole board.
Now, I've not read the articles that he submitted to the parole board. I trust you have. Do you agree that they indicate that there is a significant risk of a false positive arising from poppy seeds?
I don't believe that that's what those articles indicate necessarily, and I footnote in my brief exactly where they differ. For example, one was a study, I believe in the mid-90s, from Europe testing poppy seeds from different regions of Europe as to how those affect these testing. One was an article about different types of tests, urine versus I believe it was a saliva test. Again, I don't want to misstate what the actual was. One was a post-mortem testing for airplane crashes and how to test post-mortem for drugs in the system. And then the fourth one that was submitted at the second hearing dealt with whether or not this, I'm going to mispronounce it, but theta bane was actually an indicator or a marker for poppy seeds. And my reading of that article was that it concluded that it was inconclusive, but that higher levels of thresholds can eliminate tests that result from poppy seeds as opposed to opiates.
Is it your view that there was no evidence before the parole board that there can be a false positive arising from poppy seeds?
No, I believe that the evidence was there, and the parole board member indicated that she had read all the articles and considered those in making the final revocation determination.
So if there is evidence of a meaningful risk of a false positive, would that not entitle a defendant to some discovery to explore whether or not that risk occurred in his case?
If there was a meaningful showing, then again, it would be within the, let me take a step back to the first hearing with the hearing officer or the hearing examiner. If he had presented evidence that really caused her concern, she certainly could have asked for this other additional information. Same thing with the second hearing officer. If he had gone out and gotten this information and it caused more concern, he could have presented that at the final revocation hearing. And furthermore...
I'm sorry, so you're saying the Commonwealth has no obligation to provide that discovery, that the parolee is on his own?
Well, as was stated earlier, discovery is not necessarily a part of the lower due process that's been implicated.
Isn't that the issue here?
SL, this is CPSL, isn't it?
That's correct.
So every time you find a violation under 133DC, it gets added on to the sentence, right?
If there is a violation found after the due process procedures, the multiple hearings, the presentation of evidence, then the CPSL statutory penalties kick in, yes.
I
So
guess
his suspended sentence of 30 days essentially was imposed here. Is that what you're saying?
What I said in the brief is that once the parole board found a revocation, then it had no discretion but to impose that sentence.
Are you sure that that's the case? I read in some of the briefs, well, I thought you just said the parole board doesn't have to,
we gave warnings.
you can give warnings.
Well, there's two different parts here, and that was the distinction I was trying to draw in my brief, which is what happens once a revocation is found and the actual finding of the revocation. So the parole board doesn't have to find a revocation, but once a revocation is found, then it has no discretion. It's following the statute that has been given.
And then when he was put back, when he was incarcerated, SDP proceedings were reinitiated.
That's correct.
Do you, I guess this is, and maybe you address this, but because, as everybody acknowledges, the CPSL parole is different in kind from traditional parole, and actually explicitly states that it is adding on to the sentence, would the due process, procedural due process rights be different than Morrissey might indicate?
At this time, those due process rights aren't different. And the reason I say that, I think everyone concedes that the penalties under CPSL are different than they are under traditional parole. But by the CPSL statute, the revocation process is the same. The statute says parole is supposed to treat parolees as any other parolee.
I guess I'm just wondering about the underpinnings of that, whether, because the consequences are substantively different, more procedural rights should apply.
That certainly should be a consideration. I would submit that this case is not the one to do that on, given the factual record that's presented, where we have he was represented by an attorney, he was given the notice, he was allowed to present his evidence, he was allowed to submit articles, and his testimony was not found to be credible by the hearing officer. Now, to pose it a different way, if he had come in and said, parole board, I know I ate 5 poppy seed bagels yesterday, here are all these articles, I think that these test results would show that my result is, or my positive screening is a result of poppy seeds as opposed to taking opiates. Then, and let's assume that the parole board had denied him discovery at that point, that might cause more concern. I would suggest that this is a long way back from those concerns.
Yeah, but isn't there a class issue here? I mean, I assume he was homeless, Mr. Gangi?
I believe he was living at a homeless shelter at the time.
Okay, so, and most of the persons who are on CPSL are homeless, which means they may not be buying their own food. They may be purchasing it at a homeless, or they may be obtaining it at a homeless shelter where they don't really know exactly what goes into the ingredients. So I mean, yes, if you can go to the bagel place and say, I ordered, but if you don't have any money, you take what you get. Isn't that a problem?
Perhaps, but maybe that's a problem as opposed to requiring more due process at the hearing. It could be remedied by, for example, the parole board saying or giving a notice to all parolees, don't eat poppy seed bagels. I would suggest that that's a less restrictive.
That assumes they know what's in the cake that's served on Easter. Is it your view that there is, I'm trying to think, that there are circumstances in which there would be a due process right to discovery at parole hearings?
I would suggest that it's within the hearing examiner's discretion.
I'm referring to rights, not discretion.
Right.
Is there any due process right to discovery in any circumstance at a parole hearing?
I would suggest that the rights have been laid out and that the case law says that the rights are flexible once they have been met. That's where I was getting to the hearing officer's discretion, is that once the basic rights of notice, opportunity to be heard, opportunity to present a defense have been met, the minimal due process rights have been met, then there's discretion as to allowing extra discovery at that point.
And can that discretion be abused, such as to constitute a due process violation?
I think it could be abused, and I think if this court were to look at or evaluate the hearing officer's discretion, that would be under an abuse of discretion standard as opposed to a constitutional right.
But of course, we would, I forget, oh, I know why this case is here. But I mean, we generally, that's not reviewable at all, is it?
I'm sorry, what isn't reviewable?
Well, a parole revocation never comes to court.
Unless, and to answer your question, it would come to court if there's an allegation of a due process right, at which point there would be the opportunity to review it to see whether or not due process was met.
Well, it would be what? It would come to court in the form of the action for declaratory judgment, which is what this came in?
That's correct. And I would also suggest that there are opportunities to appeal within the parole board that weren't utilized here, and those regulations allow for reconsideration of new evidence. So, for example, if Mr. Gangi had gone out and gotten his results and really believed that there was a question, he could have raised those through the parole board's regulations. The parole board could have reconsidered it and could have reconsidered its decision at that point. That wasn't utilized. That's unfortunately not part of the record, and to this day, we don't know what the test results are. So,
Have we ever said that the certiorari statute does not apply or does apply to parole board hearings?
standing here today, I'm not familiar whether or not the court has said that.
Okay.
Unless there's any further questions, I will rest on my briefs.
Thank you.
Counsel.
Thank you.
You mind if we just